Yes, we have a number.
We have a quorum now. Thank you. We're back in the Judiciary Committee. A couple final things before we wrap up for the day. We are looking at a matter or issue that we want to put into, or we're going to consider putting into the miscellaneous judiciary bill. And it has to do with repealing a crack statute. And I will turn it over to Legislative Counsel to explain what this is all about.
Good afternoon. For the record, Michelle Childs, Office of Legislative Counsel, and we're looking at two sections pertaining to repealing the crack statute that you're considering adding to the miscellaneous judiciary bill. This committee has passed this language twice in the last biennium. One of it was in your drug standardization penalty bill that you passed that the Senate did not take up, but then it was also in another bill that where you created the study for the benchmarks for figuring out how you kind of tier the amounts within the drug statutes. And that bill was vetoed by the governor. My recollection is he did not mention this. This wasn't the reason for it. It was that he didn't like the study. But this was in there, and so that went down with the whole bill. So essentially what it does is if you look at the language, there's two sections. The first section is amending the definitions in Chapter 84 in your regulated drug chapter and just striking crack cocaine because you would no longer within that chapter make a distinction between powder cocaine and crack cocaine. And then in Section 2, you're amending the cocaine statute. The only place that where it makes the distinction between cocaine and crack is in the trafficking language. So it doesn't have differential penalties earlier in, whether it's for possession or for dispensing and sale, it's only on trafficking. And so you see that the language in C2 is struck so that any charges that would be brought for possession of crack would be brought under the cocaine provisions. So just a little bit of history. The first distinction in the law with regard to crack and powder cocaine was in when Congress passed the Anti-Drug Abuse Act in 1986. And in that they established a 100-to-1 ratio of cocaine to crack. And then they changed that in 2010 when Congress passed the Fair Sentencing Act, and that reduced the ratio at the federal level to 18-to-1 from 100-to-1. The General Assembly here adopted this crack statute in 2003. So before the downgrade to 18-to-1 ratio. But if you want to, I don't know if Marshall's going to testify on it or others, but the policy behind it that's been articulated for why there shouldn't be a differentiation is that it's the same drug and you can have resources, but you can Google and look at kind of the policy approach around saying that there really isn't that the distinction is a false one, saying it's all cocaine and that you shouldn't punish depending on what form it's in.
Right. So I am going to ask, actually, Eric, well, no, we're not going to have a straw poll on this one yet because we don't have enough people here. But I'll have this available for our witnesses tomorrow because we do have State's Attorney and Marshall are going to be in testifying tomorrow. We'll just make sure this is in front of them as well. So that's not for your concern, Eric. But I'm wondering if the three things that we both had a straw poll on, whether you can have that into a next version of S33 by tomorrow. Yeah, I assume that you've been keeping up on that anyway. That's
the one you just mentioned.
H22, H212, and H250. That's the drug alcohol one. Is H250.
Oh, right.
Yeah, just
the DUI one.
The DUI one.
And 22 was Michelle. Was that the other one?
Yes, that's the no sex with.
I think that's all right. The three. I'm recalling right, unless you ran across any other ones that we missed.
Tom,
Oh, right.
that's the language you guys passed twice last biennium.
Okay.
It's not any different. So it should look familiar.
Yeah, well, we have to figure that out. Well, after you get up here and tell us a little bit about that, I can see what the committee thinks about where we should put that.
So we're not voting on, we don't have to.
We're not going to
this one?
vote. We will, but I think that people need to have testimony first on this one. I understand. I do remember that state's attorney gave very good testimony last year that really helped us understand that this thing should go away. You know, I mean, the crack statute.
No, so this is, we've seen this language before. What happened? It got pulled out of bills.
It was in one bill that died in the Senate, and it was in another bill that also had a provision that established a study committee looking at establishing benchmark dosages for all of the different drugs in Chapter 84. Remember, so like kind of.
A few years ago.
No,
No?
just last year. I know it does, but it's hard. It all blends together these days.
I know one time when we worked on some of this stuff, we made different amounts for like hash and weed because hash is concentrate.
Right. You guys didn't, in the bill last year, didn't establish that, but had a task, a study committee to look at creating those thresholds to kind of standardize it. So when if you possess this amount, this is what would be considered a personal benchmark amount, and then it would increase. And that bill was vetoed by the governor, and the veto message, he was concerned, he did not like the study committee. It was not about crack. Or I don't recall that being mentioned. It was about the study committee. But I'll go back and check the veto message.
So I don't want to complicate, well, I'm going to. But just because a bill passes out of this committee doesn't mean we all voted for it, right? I mean, is there ever a record of how the vote comes out here?
So, yeah, there are records here. I can tell you that you and Bob and Tom voted against the bill, but during the course of testimony and discussions about it, everybody seemed to be fine with this part. It was a couple other parts that people had a problem with. Maybe I misremember it, but you get to look at it anew with testimony tomorrow anyway.
Okay, thank you.
But that is my recollection, that this was not the problem part of what we passed out last year. Yeah, I lived that for 5 weeks, so it was.
So since this under C trafficking, is this existing law now because it's not underlined? Or is this new language? It is existing.
Yeah, this is existing law. It was passed in 2003. And the only place that crack appears in the chapter is for trafficking under cocaine. Otherwise, if you have an amount that's less than the trafficking amount, it would just be charged under the rest of the cocaine statute. It's only with regard to trafficking that there's a distinction between having a far less amount of crack as compared to powder cocaine.
So the only difference is moving, I'll call it the title trafficking and the not. Right?
I'm sorry?
I succeeded in confusing you. No. So C trafficking is moved up from here, one, and down here, the lines are numbered, but just not less than 400 grams is the only two changes other than.
Well, you're getting rid of the crack.
Well, yeah, and I was going to say that.
Yeah. Yeah, you're just saying that whether you have powder cocaine or you have crack cocaine, you just charge under the cocaine statute. You don't have a separate lesser standard for crack.
Right. So, and I'm pretty sure you said it earlier. One time they used a 400-to-1 ratio as far as crack to.
It was 1986. Congress passed sweeping. What was it called? The Anti-Drug Abuse Act in 1986, and that's when you first saw the distinction at the federal level between crack and powder cocaine, and they established a 100-to-1 ratio. Then in 2010, when they did the Fair Sentencing Act, they reduced that to an 18-to-1. There have been a number of efforts in Congress in recent years to do away with all of that and just have it 1-to-1. And I think it passed the House, and then it didn't get in the Senate. It didn't pass in the Senate. And then now that I think things are kind of flipped, I mean, I think it's just a lot of things are not passing.
Right, so is there any studies out there, I gotta assume there is, that, and I'll just use, say, 5 grams of coke makes 5 grams of crack?
I think I would defer to the witnesses on that. I think I don't want to,
Yeah.
but I think there are, I don't recall when we have taken this up earlier. I don't remember any of the witnesses coming in and advocating for keeping the crack statute and saying, here's a reason why, but I could be mistaken. I think there's a fair amount of folks out there who are saying it should just be 1-to-1, but.
Okay, good. Ken?
What was the 2003 year that you referred to?
That was when Vermont adopted the language that struck in subdivision C2.
So I was gonna tell you, I was blown away with 2003, and then when you said 1986, my jaw just totally.
That was Congress, yep, yep.
Oh.
Can I ask you a
Thank you.
completely unrelated question while I have you right here? Were there any changes in S37? We're all good for tomorrow? Definition sections comport with each other?
As far as I know.
Okay.
I haven't, I know Jen was doing a walkthrough with them. I haven't heard an SOS from her or anything like that. So I think everything's fine with the shield bills.
All right, thank you.
Yep.
Thank you, Michelle. And like I say, we'll have a little bit of testimony on this tomorrow from some of the witnesses, and we'll.
So is this potentially going into the miscellaneous?
Yeah, if we all agree. So we'll try to have a straw poll in this one way or another tomorrow morning.
You mean if we don't all agree, it won't go in there?
Well, you're the exception. If you don't agree, we're still putting it. If the two Toms agree, then it's good. But
Okay.
thank you, Michelle.
So do you want me back when you hear from witnesses, or maybe?
I think we're probably good.
Right. Janine, if you don't mind, just send me an invite and I'll just get it on my calendar. That way, if I can watch from my office, I will.
Great, thank you.
Thank you.
All right, so if we could, Eric could join us as well. And so Eric is going to just go over language that we already looked at earlier today, or at least had a little testimony on, and I explained it briefly. The hospital, the exceptions to firearms not being allowed in hospitals. We had a little bit of testimony from Allison she from Everytown, and Chris Bradley from the Sportsman Federation. But one of the questions is whether we put this in the miscellaneous bill or in S4. I don't know if people have strong feelings about that, but I guess we'll find out. But I didn't really do a walkthrough. I just explained really high level. Eric, if you could just give us the quick down and dirty about, and people should have it still on their desk somewhere, presumably. This is 13 VSA 423. It's something we looked at earlier or late in the morning with Chris Bradley.
What are we looking at now?
It's possession of firearms in hospital buildings prohibited. Yeah. So, thank you, Eric, for being here.
Good afternoon, everyone. Eric Fitzpatrick with the Office of Legislative Counsel. The chair mentioned about a possible amendment to the miscellaneous bill S33. And if you do, it's a one-pager proposing an amendment to the existing statute on possession of firearms in hospital buildings. And if you are able to see it, I'll point out initially that there's a typo. The very first line, it says 13 BSA 423. It should be 4023. That's the correct statute.
Right. 4023 out there, yeah.
And that statute you passed last year in Act 87, which was an act that contained a number of different firearms-related provisions. This was one of them. Had to do with possession of firearms in hospital buildings, generally prohibited by the legislation you passed last year. It's only it's a fine-only crime. You see in subsection B, it's $250 only. And there was an exception in the legislation that passed last year for federal and state law enforcement officers for legitimate law enforcement purposes. That's in subsection C. The proposal that you see in front of you, which has also been introduced as H-172, which is a bill that was introduced this year, is to add a few other parties to that exception. In other words, a couple of other professions who would be permitted under certain circumstances to possess a firearm in a hospital building. And you'll see there are four that are proposed to be added. I should mention that each of these four are also exceptions in New York's general statute that they have that prohibits possession of firearms in hospitals. They have a list of exceptions as well. These four are included in that one as well. That's where they were drawn from in part. The first one has to do with security guards or private investigators performing their official duties. They have to be licensed because security guards and private investigators are licensed by the Office of Professional Regulation. And additionally, there's a specific statute in their licensing chapter, which provides that they can't carry firearms unless they are specifically certified. Exactly. And to be certified, they have to take a firearm safety training program approved by the director of OPR. So they have to take that training class and then get certified, and then they can carry a firearm for purposes of their profession. So that's why that cross-reference you see, they have to be licensed under Title 26 and possess a firearm certification that is talked about in the private investigator and security guard license statute. So that's the first one, subdivision 2. Subdivision 3 is a corrections officer if they're performing their official duties. Unless and this is an interesting provision, that the Commissioner of Corrections has the authority statutorily to direct that corrections officers not carry weapons while on duty. So specific corrections officers can have that direction. So this is making sure, here you'll see, generally permits corrections officers who are in their official duties unless they've been directed not to carry weapons by the commissioner. Just to make that consistent wouldn't make sense if the commissioner told them you can't carry weapons while on duty and you allowed them to carry them while they're in the hospital while on duty. So that's what that is referring to. That's the second one, second new one, I should say, subdivision 3. Subdivision 4 refers to law enforcement officers of another state. So if they are authorized to carry a firearm by their own state or local law enforcement agency, and they're carrying the firearm for legitimate law enforcement purposes, they also would have an exception and be permitted to carry in a hospital building. And lastly, member of the National Guard, Vermont National Guard or National Guard of another state or of any of the U.S. Armed Forces who's on duty and acting under state or federal orders. I checked that language with Damien, who handles the military legal issues for our office, and he said that that was the proper language to use if you want to make sure that the person is not just happens to be enlisted and is in the hospital, but specifically on duty and acting pursuant to orders. So that's the proposal, to add those exceptions to the existing exception for law enforcement for possession in the hospital building.
Questions?
Operating officer?
I could tell. You took off your glasses.
Right. No, my giveaway out of my
Yeah, all four of them are new, 2 through 5.
So,
Law enforcement's the existing one.
Go ahead.
so number 5, National Guard, and everybody else. So if they're on duty, so a National Guard, if you're full-time National Guard, you're pretty much a 9 to 5-er in a sense. So if it's 6 o'clock, I can't carry. Is that what that means?
I'm going to defer to Damien on that.
Okay.
I have absolutely no knowledge of that area of the law. I checked with Damien and got the language from him. So I'll let him know that you have some questions on that.
Okay.
Helpful. Yeah.
If that's what it is, I'd like to have some discussion in the committee around active duty.
Sounds good. I'll let them know for sure.
Do you want to circle around to them and just find out that?
Yeah.
Touch
Because
base
it
with
may
Megan,
be,
'cause, and if you think we need to have further discussion and we're if you're
Yeah.
satisfied with what we have. All right, any other questions? I think I'm inclined to have this in the S4 because S4 is already controversial and whenever you have anything that says firearms on it, rather than in the miscellaneous bill.
Sure. Either way is fine.
Yeah. And the connection, I think, is not, it's not as closely connected to the miscellaneous procedures as it is to the firearm violence.
Right.
It's more germane to that, even though there may be limits on germaneness in the miscellaneous bill. We should push the envelope, but
Sounds good. So for the amendment to S4 then, sounds like.
yeah, but
Right.
there's nothing to amend on S4. We're going to have discussion tomorrow.
Right.
If you're around in the afternoon. If we
Yeah, that's on my calendar. Yeah.
Yeah, so we're going to have some heart to heart on S4 tomorrow afternoon. Figure out what we're going to do with that. And then with
Yep.
and then S6 as well. So we have both of those.
Maybe I'll bake tonight, bring cookies for tomorrow.
yeah, that's what I need. Make good cookies also. Still like.
What time?
For Jeff Sanders. Right.
So as far as the S33 amendment, things to add to miscellaneous. Just, in fact, I'm just going to move over here because I had that amendment going.
Did you say S33?
Yes.
Yeah,
It's just right there.
yeah, we're taking that up tomorrow morning.
So we're going to add the one that you mentioned earlier, the tobacco.
Yep, that's H212, yep.
Additional ones I had in here so far are, was a couple of, did Justin Kolb or anyone from the Attorney General's office come in on the environmental claims?
Well, thank you. No, he's scheduled for tomorrow.
Okay.
Yeah, he's scheduled tomorrow, so we can modify whatever.
Yeah, there's a little bit of a technical.
Unless you wanted to put his technical thing in, he can talk to it. I mean, if it's not substantive, big policy decisions, it's just technical.
Yeah, I'll put it in.
Yeah, just flag it.
Yep,
Yeah.
sounds good. Firearms buildings we're going to move. I think this is H22, sexual exploitation of the person being investigated, detained, arrested.
Yep,
So that one's in,
yep,
right?
yep.
Where's that in?
The miscellaneous bill. Made a straw poll, you were here.
What was that number?
H22.
Here?
But it's not as introduced, it's a new version. I mean, you should have it because we went over that last Friday.
And the cocaine, crack.
We're not going to put that in until we haven't had a straw poll on that. We want to hear testimony before we put that one in.
Okay. We don't have it in the document yet.
Correct.
All right.
Yes.
And then the request from the state's attorneys about blood tests for
Yep.
find evidence of alcohol and drugs.
Yeah, that one phrase.
Yeah. All right.
Did you find any other things in your folder?
Didn't.
No, that was it. The combo. All
There
right.
were a couple other things in the folder, but they already got into.
Okay. All right, good. So tomorrow morning, 8:30, we're going to be having about an hour of testimony on 222. It's a narrow. I don't know if have you gotten the language yet from? Probably not. I need to get that language. I distribute, so I will do that. But it's drug testing, and we'll then move on to S33. In the afternoon, we'll have lots of committee discussion. Figure all that out. All right, thank you. We'll adjourn until tomorrow at 8:30.